Constitution was drafted and formalized. And it became a debating
Do you
matter.
think everyone did not realize that they were presenting a draft that purposely did not have recall in it? Is that really what you're suggesting at this point
Absolutely,
in time?
Justice Lavecchia. It was not considered. It was not rejected.
Well, the Constitution did not go into effect until the ratifying conventions adopted it. So, correct?
That's correct,
So
Justice
you would
Allen.
agree that the conversations during the ratifying convention debates are important to our discussion, correct?
I agree it has some significance,
Okay.
Justice Alvin.
You mentioned the ratifying convention in New York.
Right.
Okay. Are you familiar with Gilbert Livingston?
Yes.
Who was one of, are you familiar with the resolution that he introduced?
Yes.
Okay. So I'll read it to you.
Please.
Resolved that no person shall be eligible as a senator for more than 6 years in any term of 12 years, and that it shall be in the power of the legislature of the several states to recall their senators, or either of them, and to elect others in their stead to serve for the remainder of the time for which such senators or senators so called were appointed. Now, he wanted that attached, that amendment attached to New York's decision before New York adopted the federal Constitution. So my question to you is, why was he making that resolution, and why was Robert Livingston and Alexander Hamilton and Melancthon Smith all debating that issue before the New York ratifying convention if they believed that the federal Constitution included a recall provision?
Justice Alvin, this is not legislative history that you're describing, because the Constitution has already been finalized. It's already been ratified by other states. It's already been ratified, and people
it's not
are coming
going
up with
into
arguments.
effect until 9 states have ratified it. And it wasn't ratified by the time the New York delegates had met at that ratifying convention.
That's
it wasn't in existence. The Constitution
That's correct, Justice Alvin, but this is late in the game. This is not intent
This
in
isn't late in the
formulating
game.
the Constitution. This
is in
lawyers.
1788. Okay, that's when those ratifying conventions were. September 17th, 1787, they signed their names. It goes to the states. That's the New York ratifying convention. These people are all debating about whether or not there's a recall provision. Now, you tell me why they're debating that if all of these people thought there was a recall provision in the federal Constitution.
Because, Your Honor, they're politicians fighting the Constitution for a variety of reasons, and for reasons much bigger than the issue of recall. New York anti-federalists oppose ratification of the Constitution for reasons much bigger than recall.
I just read to you a resolution introduced by Gilbert Livingston that precisely dealt with the recall. He was demanding that that be attached to New York's concurrence to the federal Constitution. And I can read to you, if you want, the debates going back and forth about whether or not a recall is good or not good. All debated. And you're telling me they were just wasting their time because that was already in the federal Constitution.
Your Honor, I'm saying, as the scholar said, it was an oversight. And now, after a number of states have ratified it, people are starting to pull up a lot of oversights.
Well, tell me
why. It's a brief, elegant document. It doesn't have everything in there. The Constitution doesn't say that the national government can establish a national bank. It says you can't. It doesn't say. In fact, they rejected it, and then the government did it anyway.
Let's stick to recall. Tell me why Luther Martin, George Mason, Elbridge Gerry, all of whom were delegates to the federal Constitution, all of whom did not sign the federal Constitution, all spoke down the federal Constitution because it didn't have a recall provision.
Justice Alvin, I would question whether that was the reason they were really against ratification.
Well, I can give you their words.
Against the Constitution for a much bigger reason.
You mean they were just using those words, talking down the recall provision because they had ulterior motives?
I'm saying their opposition was much bigger than recall. If I could, let me read the words of George Washington, which I think would be the starting point here. It was in all my briefs. Petitioner didn't mention it once in his argument. Less than 2 months after George Washington presided over the Constitutional Convention, He wrote a letter to his nephew, Bushrod Washington. Okay, this is a sincere letter. This is not an attorney arguing. This is like writing to his diary. Okay, and he's telling you this is the way it is. Quote, "The power under the Constitution will always be in the people. It is entrusted for certain defined purposes and for certain limited periods to representatives of their own choosing. And whenever it is executed contrary to their interest or not agreeable to their wishes, their servants can and undoubtedly will be recalled." George Washington, less than 2 months after he presided over the Constitutional Convention. Now, in sort of weighing the evidence, historical, wouldn't that have tremendous evidence? Wouldn't that be
Well, how about the
significant?
Articles of Confederation, which specifically had a recall
It did.
provision? So would you concede that the people who met in Philadelphia knew the term recall, were familiar with it? It was not only in the Articles of Confederation, it was in at least 2 state constitutions or colonial constitutions?
Justice Albin, the Articles of Confederation is a much more detailed document. And recall, although it was provided for, was not used. So, with all due respect, I don't think it was preeminent in the delegates' minds, this power of recall, because it wasn't used. It wasn't a topic of discussion. The Constitution is a brief, elegant document. There are many rights of the people that are not in the Constitution. There's no freedom of association.